Good morning, hello, and welcome to today's webinar. My name's Amanda Chadwick. Today is the 27th of February, and we're about to talk about Brexit. It's such a hot topic, as we all know, because it's going to affect every single one of us. It's quite an in-depth discussion we're having today about Brexit. There is, I will say to you, some slide reading because I am talking about facts. I don't want you to scribble down notes or anything like that because these slides will be available to you. And please note the detail contained within this webinar is based on GB employment legislation. Clients in the jurisdictions of Northern Ireland, Republic of Ireland, Jersey and Guernsey and the Isle of Man are asked to please contact us for any information that may affect you. So today's objectives are understanding and helping employees with settled status, no deal and the impact on your workers, also managing Brexit uncertainty and the future impact that it will have. So interesting facts for you. On the 23rd of June, as we all know, 51.9% of voters chose to leave the EU. So I don't know if you know this either, but the UK joined the European communities in 1973 under the Conservative Party. Also, just a little bit of trivia for you, is in 1972 we saw that employment contracts were a legal requirement. So there's a little bit of interesting trivia for you as well. So 1975 saw a referendum which endorsed continued membership of the European communities that were set up after the war, and a little bit the focus has shifted a lot on what the European communities represented. In the 1970s and the 1980s and in 1983, the Labour Party election manifesto advocated a full withdrawal from the European communities. And then what we saw in 1993 was the EU was formed with 28 member states. So we are going to apparently at this moment in time remove ourselves from the European Union on the 29th of March at 11 p.m. Okay, so Brexit key dates: 23rd of June 2016, the EU referendum where the British public voted to leave the European Union. On the 29th of March 2017, Article 50, the British government formally submitted their decision to leave the EU to its 27 other member states. I believe, actually, I think after we leave the EU, if that happens, let's say, at the moment, everything is actually speculation. But if we are leaving the EU on the 29th of March 2017, I do believe there will be other member states that will consider it as well. On the 26th of June 2018, the European Union, the withdrawal bill, which takes the UK out of the EU, receives royal assent, becoming an actual act. On the 15th of on the 15th of January 2019, withdrawal agreement is rejected by Parliament. On the 29th of March 2019, as I said, at 11 p.m. in the evening, Brexit Day, the official date Britain will leave the EU. We have heard lots of media reports at the moment talking about extension, so we'll wait to hear about that. And we'll wait to see what the outcome of that is. Key concerns at the moment, though, let's talk about what information we have at the moment, because that really is the most important part for us, the people that deal with the employees that are all worried, the EU workers that we employ, and they're absolutely worried. A lot of them really worried about their future within the UK and what we can do to support them. So right, so can my existing EU workers stay in the UK post-Brexit? This is the questions we're being asked. Can I hire new EU workers post-Brexit? And what responsibility do I have to check employees' eligibility? Right, first of all, let me just stop for a second there and remind everybody listening to me today in HR, in employment law, managing a business, and we have all different levels of skills listening to me. So bear that in mind if you are an HR expert and know absolutely everything, is that I do have have other people that don't have that relevant experience, that everybody who works for you, first of all, you should be checking that they have the right to work in the UK. That's something that you should be doing. So make sure that you are aware of that. If you need any help with that, we do have due diligence checks that you can look into at the CIPD HR Inform. Okay, so as I'm sure we all know, following the referendum of June 2016, the UK officially decided to surrender its membership to the European Union. The European Union Withdrawal Act is a key piece of legislation in the process, as this repeals the European Communities Act 1972. The piece of legislation which entered the UK into EU membership, therefore entitling the UK to leave the EU on Brexit Day. The Act automatically brings all EU laws and rights in force on Brexit into domestic law, meaning all EU employment rights will continue to have effect after this date. Now, much media attention has surrounded the recent parliamentary discussion and dispute with regards to the rejection of the withdrawal agreement and where we are at currently with regards to the exit from the from the EU. So we're waiting to find out more really about what is actually happening there and whether we have any more information about that. What is quite interesting is I do feel that the government, regardless of who they are, should have clicked together and supported businesses and kept them really really informed of what's going on, and kept us more into kept us more information and made it really easy to understand, which I think people have failed on. Okay, so rights of EU workers. Okay, so if there is a deal, this is what we've got. Okay, so freedom of movement will continue during the implementation period, and it lasts until the 31st of December 2020. EU workers can continue to travel to the UK to work without any restrictions during this period, and EU workers can apply for settled status to be granted leave to remain in the UK after the end of the implementation period. So this is the rights of EU workers if there is a Brexit deal. A no-deal Brexit will be looked at later on, so let's just focus on the deal fact side of things. Organisations will be acting within the law if they continue to employ EU nationals or offer new employment to EU nationals during the implementation period with normal right to work checks, i.e. checking an EU passport. We're going to discuss settled status in more detail in the following slides, okay? So, rights of EU workers from 2021. Okay, so from the 1st of January 2021, a new immigration policy will be introduced in phases. So what we have is this applies to all workers regardless of their nationality. So we have under a 12-month visa, workers will not be entitled to benefits, can't bring dependents, and the 12 months won't count towards settlement. How attractive is this short-term visa for low-skilled temporary seasonal EU nationals who remain entitled to travel to other EU countries without these restrictions? So how attractive will that be? We don't know. Organisations and sectors which rely heavily on these types of workers, so we're looking at really the care, the hospitality, retail, agricultural, may experience, a loss of workers. For long stay visas, there will no longer be a cap on the number of high skilled workers, and the resident labour market test will be removed. So the minimum salary threshold is muted to about 30, around that, I'd say around about 30 grand, but a consultation on the level of this and shortage roles such as nurses and doctors, it will be carried out. They will need to be sponsored, and it is anticipated that fees such as the immigration skills charge, so that normally is about 1,000 per visa for large organisations, and it's actually reduced amount for smaller organisations, will remain in place. There's a phased introduction. We require more details on timelines and specifics in relation to how this will apply, which we don't really have everything on that. So new 12-month visa for low skilled workers where security checks are carried out in advance, not very attractive what's being offered. Immigration system for long visits focuses on skills that meet Britain's needs, really. I think that's what a lot of people were asking for. Applicants for long stay visas will have to meet a minimum salary threshold, and a consultation will be carried out. So, understanding settled status. So, you may get employees asking you for assistance with applying for settled status, and they should be referred to the government website, which offers advice and guidance. At the moment, we have a Brexit hotline for people that are inquiring about Brexit. So we keep it current and up to date, and we have a news feed linked to anything that's coming from Europe or the Houses of Parliament. But you will get employees that are asking you about it. Refer them to the government website, and it will offer them advice and guidance. You need to reassure them, really, because a lot of people out there are really, really worried about what they should do. It tells them how the scheme operates in practice, and it will depend on whether the UK leaves the EU with a deal in place or if there is a no-deal Brexit. The dates for the scheme will vary depending on the circumstances. So understanding this settled status is EU nationals have accrued 5 years continuous residency in the UK, and they can apply for this status, giving them indefinite leave to remain. Pre-settled status, so EU nationals who do not meet the 5-year threshold can apply for this status, which grants leave to remain in the UK for a further 5-year period. And once an individual with pre-settled status has 5 years continuous residency, they can apply to upgrade to settled status for free. Okay, so that's where we are on understanding settled status. So the key dates for the settled status: we've got EU nationals with 5 years residency in the UK by the 31st of December 2020. They can apply for this settled status. And those with less than 5 years residency by the 31st of December can apply for pre-settled status. So, and applications made online from March 2019 must be submitted by the 30th of June 2021. If there is a deal, the settled status scheme looks at length of the residency until the end of the Brexit implementation period. So remember that's actually, as I reminded you, 31st of December 2020. And in the event of a Brexit deal, there is a 6-month extended window for applications to be submitted once the implementation period ends, allowing applications to be made until summer 2021. So what I would say to you is there is real confusion, and you're going to be asked repeatedly. And I would always say, just seek advice, refer to the government website. If that's not helping you, ring us up, speak to us, and we do have a hotline there. And it's remembering these dates, because I'm sure once you come off the webinar and you haven't received the slides, the dates won't stay in your head and you will forget them. So I will get these slides over to you. I think it's a good reference guide, but if I do send the slides to you, we do send them to you. Remember that they can change. It's relevant now, but they can change. Just bear that in mind. Okay, understanding settled status and applications. So individuals will need to ensure they can prove the following. So their identity, their residence in the UK, their relationship to an EU family member living in the UK if they're from outside the EU. They will also need to pass a criminal record check. So things to remember: the Home Office has recently announced details of the procedure of applying for settled status, whilst confirming the government's default position would be to grant, not refuse, and settled status. Refusals really are only likely to be issued if there is a very good reason, according to the Home Secretary, such as serious and persistent criminality. And we're not talking parking fines here, everybody. We're talking about real criminal acts. Applications will cost £65 for adults and £32.50 for children, and be free for EU nationals who already have residency or indefinite leave to remain in the UK. Okay, so understand the settled status again: applications, residency. It uses national insurance numbers to carry out automated checks on tax and benefit records. Additional evidence includes energy bills, bank statements, council tax bills, and proof of employment. So the system needs at least one data point for each 6-month period of residence. Automated checks will look back through tax and benefit records for the previous 5 years, and I believe, a legitimate EU worker that's come here, that's actually, it has worked in the UK, that will have all this as evidence anyway, to provide the previous 5 years history. If enough data to show that the individual's 5 years residency, they're not required to do anything further. If the records don't show residency for 5 years, they'll be automatically presented with pre-settled status. And to change this, they can send in additional documents to prove residency, touching on each 6-month period over 5 years. And they can either scan them, send photos online, or send them in. So they've made it quite easy, like lots of banks do now, where it's not just going to the post office and sending a letter off and printing it off and email. They've said you can actually send photos over and you can scan them as well. So they have made it easier. Some employers are helping their employees with this process, so it's a good idea to know all about this. So again, criminal record check will examine anyone over 18 to ensure they have not committed serious or repeated crimes. They do not pose a security threat. As I said to you, minor crimes like speeding will not, throwing litter, that type of stuff will not affect eligibility. But other convictions will be judged on a case-by-case basis. So if an individual has a prison sentence, they will usually need 5 years continuous residency from the day they were released to be considered for settled status. And the Home Office have again confirmed the government's default position would be to grant, not refuse, settled status. And again, as I said, refusals are only like to be issued if there is a very good reason, according to the Home Secretary. So, understanding settled status applications. Again, there's 3 methods of submitting this application using an online app. Everybody's doing online now, aren't they? Everybody's using the phone, sending a postal applicator, or using a centre in the UK. In the trials of the mobile app, just a little bit of information, there are a number of concerns reported. The passport scanning functionality only works on Android phones. I'm sure they'll look into this. But when submitting a postal application, the Home Office has limited the number of documents to 10, and there are around 50 scanning centres across the UK who will carry out passport scans on your behalf. They're trying to make it easy for people. So again, understanding settled status and the applications, reminder of the cost. It was initially announced that the cost would be charged for making applications. A number of organisations announced that they would repay any settled status fees paid by their EU staff, because that, if you think about it, I've got 4 children, so it'd be my husband, it'd be myself, £32.50 for each of those children. That has a massive dent into anybody's budget. That's a lot of money. So we're finding that there are people out there that are going to pay for those applications for the EU staff in order to encourage and support their workers faced with Brexit uncertainty. The fees have now been removed by the government. As such, settled status applications made when the scheme is fully live can be made for free. So that's really good news. Any applicants who have previously paid a fee, those who have applied during the trial periods or apply before the scheme is fully live, can apply for a refund. So details will be announced by the government on how to do so, leaving it a little bit late, in my opinion. So understanding settled status, the facts. What about Irish nationals? Well, Irish nationals will retain the right to freely travel to and work in the UK under the common travel area. They will not have to apply for settled status, but can choose to do so. So again, what about EU nationals who already have indefinite leave to enter or remain in the UK? EU nationals who already have indefinite leave to enter or remain in the UK retain eligible to enter and work in the UK. They will not have to apply for settled status, but can choose to do so. Again, a question. What about EU nationals who already have a permanent residence document? These individuals will still need to apply for settled status to be entitled to remain and work in the UK. The permanent residence document can be used as proof of their residency when making their application. So, Understand, that was my reading off the slide bits there, by the way. Understanding settled status and the right to work. Okay, so as an employer, you do have a duty to check relevant individuals have settled status to ensure they have the right to work in the UK and are not an illegal foreign worker, as the law stands. Employers can face fines of up to £20,000 per person if they are found to have hired an illegal foreign worker. So we're talking about other workers, you know, and we're talking about all those people that are working illegal in the UK. And shame on any employer that actually is paying somebody below the national minimum living wage, that is exploiting workers. Absolutely disgusting. And so, you know, people shouldn't be working illegally in the UK. And this is going to put a stop to that. So £20,000 per employee. So EU workers who have not obtained or applied for settled or pre-settled status by the 1st of July 2021 will be considered working illegally in the UK. You have an obligation to ensure staff are working legally and must request to see confirmation they have obtained or applied for settled or pre-settled status. It will be unlawful to continue to employ anyone who has not obtained settled, pre-settled status or can show that they've applied for it. A termination process will be needed. So, settled status helping your staff. Okay, so we have produced at the CIPD HR Inform a number of documents that support this process. So letters to EU workers outlining the EU settlement scheme. So we will help you with this. We will go through the process with you. It is advisable to inform your EU staff about the need to apply for settled or pre-settled status if they wish to continue to work in the UK. HR Inform has a letter available to provide to your staff to explain what they need to do and the respective deadlines. The Employer Toolkit contains a number of guidance documents that you can provide to your staff to help them understand the scheme. This includes leaflets, it also on specific parts of the scheme, posters which you can put up within the workplace, and a briefing document to help you communicate the facts of the scheme to your employees. It is important to note that the information in the Employer Toolkit is in line with the current Brexit withdrawal agreement. I keep reinforcing this throughout the presentation. Therefore, any changes to this or a subsequent no deal will affect the information that is contained within the toolkit. However, we will update it as soon as we have information if that changes. So, settled status and helping your staff. Communication. So just to remind you, the Home Office has produced an employer toolkit to help communicate the scheme to your employees, to your EU workers. You can print out the government standard leaflets and put up posters and provide a briefing document. So, helping your staff. So, organisational support may include meeting with the EU workers to discuss the scheme and their application. I say it in every single seminar and webinar. A lot can be achieved by speaking to your staff, by sitting them down, explaining. That's when you're changing contracts, that's when you're going through a Brexit. With anything in business, speaking to your staff. They can make your business, they can break it, and you need to communicate. So, meeting with EU workers to discuss the scheme and their application, collating employment information to support a settled application, allowing applications to be submitted on work equipment, i.e. company mobile phones, allowing applications to be submitted during the working hours, allowing Home Office contact during working hours, and reminders, of the key dates and up and coming deadlines. If you are going to provide employees with internal support, ensure that it is available to all members of staff. You can actually send out an internal communication, I don't know, even on pay slips, letting employers know what they can do and what support is being made available for them. It may be best to have a designated member of the HR team who maybe deals with this matter and becomes a little bit of an expert, or somebody else within the business. And what happens then, it ensures consistency and it removes any uncertainty about who the employee should be dealing with or approach. Again, if a member of the HR team is designated to deal with settled status matters, then ensure this is communicated to your workforce, so they really are aware of who that person is and who they can go to and speak to about key Brexit information. So, no deal and the impact on workers. I think, the government should be clicking together and, you know, working on behalf of every person in the UK and getting some sort of information to everybody and reassuring everybody and working together rather than fighting amongst each other. And at the moment, there is a prospect of no deal. So if there is no deal, there will be an impact on your workers. So let's talk about the no deal and the impact it may have. So the situation changes really, as we know, if there is a no deal Brexit. Okay, essentially, this means that on the 29th of March at 11 p.m., Britain will leave the EU. Oh, by the way, the electric goes off at 11 then on the 29th of March. That's what it sounds like, doesn't it? Every time I say it, I think it looks like the world's going to end. You better rush to the supermarket, buy all your foods, you know, stockpile your bread and everything. So Britain will leave the EU without a plan in place for the future. As such, our membership will end immediately and freedom of movement will end on this date also. So basically, you need to go on holiday in the UK after that. So that was a joke. The Home Office has announced there will be a transition period after a no-deal Brexit, but it has not announced how long really this transition period will be. Again, this is further uncertainty for an EU worker looking to travel to the UK for work. So, European temporary leave to remain. This will have to submit. They will have to submit an application, pay a fee, and pass identity and criminality checks to be presented. Any stays longer than 3 years, the EU workers will have to apply for leave to remain under the new immigration rules that apply at the time. So, as you can see from the slides, it reconfirms what I'm saying to you. EU nationals who wish to come to the UK after this date will need to leave to remain. During a transition period, EU workers can freely travel to the UK for a period of 3 months. For stays longer than this, the EU worker will need to be granted European temporary leave to remain, and this lasts for 3 years. Settled status can be applied for with slight amendments to the scheme. Again, the no deal and the impact on workers. So key differences. So we've got the date where residency is counted is moved back as there won't be any implementation period. This means residency is counted at Brexit Day, or as we now know, at the 29th of March 2019. It does make a huge difference for EU workers who are not yet living or working in the UK. If they do not come to the UK within the next 6 weeks, they will be unable to apply for settled status. Whereas in a deal situation, they will be able to travel until December 2020 and submit their settled status application once they're residents in the UK. So you can see there is a big difference there. So there also won't be the 6-month overlapping window where applications can be submitted until June 2021. For anyone who hasn't made an application by this date, they will have to apply for leave to remain under the new immigration policy. So let's recap. EU nationals with 5 years residency in the UK by the 29th of March 2019 can apply for settled status. Those with less than 5 years residency by the 29th of March can apply for pre-settled status, and applications made online from March 2019 and must be submitted by the 31st of December 2020. So the no deal and the impact on workers. So reducing the impact on workers, ensure you've got internal support. You're aware of the key differences. Inform workers of changed deadlines to submit applications and provide updated correspondence, example, letters and guidance notes. So, managing the Brexit uncertainty, you're going to get employee uncertainty, and it can have a severe impact on the productivity, the engagement. So that's the engagement, the employee engagement, the performance of those members, the teamwork, retention, the morale of everybody really, and the mental and physical health of your staff. So how would you combat and how are you going to manage that uncertainty within the business? So communicating with all your members of staff really, as not even the government knows what is happening with Brexit. And again, as I keep saying, this is where they failed us. Business and economy should have had long ago, months ago, a step-by-step guide and what policies and procedures I believe they should have in place in case things do go wrong and what things they should be looking at. And So the government doesn't know much, knows what is happening with Brexit. It's unlikely that you do, but communication is all about being honest or open. So it's about telling them where you're up to, what will happen if it's a no deal, if it's a deal, if there's an extension. And I really do believe that you should gather those employees together. And that's people that are EU nationals and non-EU. That's your ordinary workforce as well. So gathering your employees together and saying A, B, and C is what we do not know, but X, Y, and Z is what we do know at the minute, and reassuring them and giving them support and access to, as I said, the Home Office. But as soon as we do know anything further, we will update you. That's what you should be saying, and it will reassure them that you're being honest, you've got their back, and removing their uncertainty about your actions and their future employment as well. So remind staff of the availability of the EAP as well. If you have that, the Employee Assistance Programme, I go on about it all the time. Everybody knows I do, and everybody knows my story as to why I think it's so fantastic. I would hope. Talk about the internal support services, provide updated information as you become aware, confirm future plans, and talk as if they are part of it still. Don't completely delete them from it. It's like a fixed term contract's coming to an end and then you don't include them in meetings. Please don't make that mistake, and stay aware of up and coming key dates. So Brexodus, it sounds like a Bob Marley song, doesn't it? Is it a myth? So, not according to Bob Marley, it's not. So, Office for National Statistics, they're saying there was a fear amongst employers that pre-existing EU nationals will choose to leave the EU as a result of Brexit, something of a mass exodus, what we call a Brexodus. Concerns that a lower number of EU nationals will mean a gap of workers in sectors such as construction, agriculture, hospitality, care, etc. Those sectors who rely on low-skilled temporary workers or skills such as construction, which are not prevalent across the British, workers. What I can say is from my experience that I have a lot of EU friends, people that are a little bit concerned, but they haven't left because they've bought houses or they committed to a mortgage, they've committed to a rental agreement. They haven't left. There isn't been this massive Brexodus. My sister, as I've told you, is one of the managers at Manchester Airport, and she depends on a lot of EU workers. There's been a little bit of a drop off, but not a huge drop off. So, but the number of EU nationals coming to work in Britain has fallen to a 6-year low. The number of workers coming from the EU was 74,000 in the year to June 2018, and it's now 60% lower than the previous year. The number of non-EU citizens migrating to the UK was the highest since 2004. Now, that doesn't include illegal immigrants. We're talking about EU nationals here today. So the future impact. So Brexodus, how to manage this. So consider future recruitment plans and staffing needs. Assess whether skilled applicants are necessary or if internal training can take place. So aside from this talk today on Brexit, I do talks on buddying people up and working with your staff. Now, you have a lot of people in your businesses. You may have, I should say, because some people listening to me only have one or two, but you might have lots and lots of people, and you might not know what their skills are. And I've said all along in all my webinars that I talk about motivation and pre-engagement is finding out about people's skills. There may be somebody in your business that's skilled in accounts, but they're working in warehousing. There may be somebody that's fluent in French or German that might assist you in any communications that you've got. I do believe that we need to find out people's skills and also their work history, and remind ourselves, because we only remind ourselves when we take that person on and then we forget about them. And people do open learning whilst they're working for you. So it might be a good idea to have a look at what skills and what pool of people you have already working for you and see if there is any internal training that could take place. And assess whether skilled applicants are necessary. Consider how competitive your recruitment process is. You've got salary, flexible working, employee benefits, employee assistance program, immigration, relocation scheme, etc. Implement internal progression and development schemes, and review whether apprenticeship schemes can develop skilled employees. And remember, if you are having apprenticeships and implementing them, they're absolutely fantastic. Well, with the apprenticeship schemes, it is a really good idea to have an apprentice agreement, and a lot of people don't. So, a hit on employment law. So let's have a look at the future impact and a hit on the employment law. Thomas Reuters, the number of business-related laws passed in 2018 fell by 27% compared to 2017. I'm sure that businesses will be pleased about that. There has been no update on shared parental leave for grandparents. There has been no update on caps for public sector payments. A good work plan and supporting legislation was released, though. So as the government becomes embroiled in Brexit negotiations and civil servant time is used up drafting thousands of pieces of secondary legislation, surveys have revealed that the number of non-Brexit related laws have fallen significantly. Will this have an impact on future employment rights and protections? We will look to see. So, the future impact, stability of current rights. So what we've got is, as part of the exit strategy, all EU laws will be automatically accepted and transposed into domestic law following our departure from the EU. A large part of the reason for the Leave vote was the desire to have control over our own laws, and so the government will be able to revise these if necessary. All European case law judgments will also be regarded as having been made by the Supreme Court as at 29th of March 2019. So all current laws that derive from the EU will be automatically transposed into domestic law. This step is being taken to avoid a cliff edge departure from the EU. And following this, the government will then decide which laws to amend, as they will no longer be held by the EU minimum requirements. And that will give them a chance to look at them again and think about whether they want them or not. The future impact and the stability of current rights. The Brexit political declaration says this: the Union and United Kingdom are determined to work together to safeguard the rules-based international order, the rule of law and promotion of democracy and high standards of free and fair trade and workers' rights, consumer and environmental protection and cooperation against internal and external threats to their values and interest. Basically, it means we're sticking together and trying to get consistency on the rule of firm and the rule of law. The original Brexit political declaration, part of the Brexit withdrawal agreement, which was voted down by Parliament, contains a promise to work together with the EU to safeguard workers' rights. Well, and I'm going to point out this promise has been criticised by parties who believe this is not stringent enough to require the UK to follow any new EU employment laws or introduce any similar protections. So again, laws which are unlikely to change. Equality Act 2010. The general principles will remain, but there may be a cap on compensation introduced. So the details of the legislation will stay. However, the government may wish to review the level of compensation, which is currently unlimited. Where it regards to holiday and annual leave entitlement, this already exceeds the minimum EU requirement. So the UK at the moment grants 5.6 weeks of holiday leave compared to the minimum EU requirement of 4 weeks. So don't forget, the 5.6 weeks include, and it should be written into contracts, the inclusion of additional types of holiday pay in holiday pay calculation. So what we've got in the 5.6 is bank holidays as well. This inclusion of additional types of pay in holiday pay calculations, so we've got overtime, we've got commission, shift allowance, etc., was introduced as a result of EU case law and provides different pay calculation requirements for the 4 weeks of EU leave and the 1.6 weeks of UK leave. There are some suggestions that this could be changed to remove the uncertainty or difficulty for employers. I think in HR, we understand it. And I think it's 5.6 weeks inclusive of the bank holidays. We write that into contracts. And I don't actually think that's going to change. Unfortunately, for most of you, the general data protection regulations, oh gosh, remember 1993, 1998, and then we've got GDPR. It needs to continue if you want to trade with the EU nationals. But what I will say to you, go to Europe. I don't think half of Europe are complying with a GDPR, do you? If you go to Greece, if you go to, I don't know, I don't think half of them are, but we are held up and we have got to comply with it. Otherwise, we get a fine. But I don't believe that half of Europe complies with this. But if you want to, this is required to comply with cross-border data protection laws and maintain the trade with the EU nationals. So the future impact, laws which may be subject to government review. So following the 29th of March, expect there to be a host of calls from various unions that will come out. I dread to think how many people are just going to come out of the woodwork talking about policies, talking about procedures to get heard. But we're going to get that many people on the 29th of March, a host of calls from various unions, MPs and managing bodies to amend laws which have been derived from the EU legislation. We don't really know what the government will target first, but the above are likely to be popular choices. So what we'll be looking at is really laws which may be subject to government reviews, such as agency worker regulations, which remain unpopular with workers and employers alike. 2P attempts, well, let's face it, 1984 was when it, prior to the last update, was when it was updated before that. So attempts may be made to simplify this, to make it more business friendly. And that's been screaming out for ages, that one. It's not new, is it? Anybody in HR that's gone through 2P would think we want it a little bit easier and we want to know what we can do and what we can't do to contracts, what we can change, how we do carry people. Lots of questions. It's one of the topics that people do ask us at CIPD HR Inform. So with regards to agency workers, the government is already removing the Swedish exemption as announced in December's Good Work Plan. The working time regulations, as we already have an opt-out choice for workers in the UK, this minimum may be removed altogether. So they may think about removing the 48-hour week cap and clarify the position on the holiday pay. And I'm going to be honest, I don't want anybody telling me what I can and can't work. And a lot of people in this country we've got the highest level of debt in Europe anyway. There are a lot of people that choose to work extra hours to book holidays. There's a lot of people out there that love to have a second or third job. They have second and third marriages and relationships, children in different relationships. They have to pay for it, large mortgages. I don't want somebody telling me what I can and can't work if I want to work long hours. But there is a health side to this as well. So don't forget that. So holiday pay, when we talk about the holiday pay, what we're talking about is the inclusion of additional types of pay in holiday pay calculations. So we're talking about that overtime, that commission, that shift allowance, etc., which was introduced, as I said earlier, as a result of EU case law and provides different pay calculation requirements for the 4 weeks of EU leave and the 1.6 weeks of UK leave. There are some suggestions this could be changed to remove the uncertainty or difficulty for employers to understand. So that's what they would maybe be looking at. So ECJ decisions. UK will not technically be bound by future rulings of the European Court of Justice after Brexit. So one of the reasons and part of the reasons to leave the EU for many was to take back control and have control over the UK laws, future rulings from the ECJ and take control back. However, any previous rulings or rulings made up until Brexit Day will still have effect and will be treated as though they have been made by the Supreme Court. So UK will not technically be bound by future rulings of the European Court of Justice after Brexit. However, previous rulings will still have an effect and be treated as though they have been made by the UK Supreme Court, such as obesity may be a disability in certain circumstances. Commission should be included in holiday pay. But these could be overturned by future UK Supreme Court decisions, as the Supreme Court does not bind itself. So what we're looking at with trade with the UK. So it is thought that the customs arrangement will minimise custom checks rather than getting rid of them altogether. as is offered by the Customs Union. This could save time and paperwork and allow companies to pay duties in bulk every few months rather than every time goods cross the border. So trade with the UK, trade deals are yet to be finalised anyway, and this is a major focus of the ongoing negotiations. The situation still remains unclear. Employers who work closely with the EU may be adversely impacted as we await to see how the new customs arrangement will impact business activities. So the key points on this: the EU settlement scheme will be fully open by the 30th of March 2019. Key application dates will be affected by the Brexit deal. A standard immigration system will be introduced for all workers in 2021. Communication, application support and deadline reminders will aid staff. Combat uncertainty by making staff aware of your future plans. So that's Brexit in a nutshell, I'm afraid. I know it is a very factual webinar that we've held today, and I know that people have been asking me questions as I've gone along. I haven't got time to answer those questions, but I will get somebody to contact you to answer those questions on my behalf. If you do have a question, I haven't had time to answer it, please email in events@hr-inform.co.uk. If you would like to know more about the CIPD HR Inform demo, you are entitled to a free 24-hour trial. And as you can see on there is a telephone number to ring at 0333 207 5658. And on there, an hr-inform.co.uk will tell you lots about our products. Anybody who's listening to me today can save 50% off the CIPD HR Inform subscriptions from watching this webinar. And don't forget, as I said to you, there's plenty of letters on there, information, guidance. If you'd like to follow us and like spending time with us and want to be into our friendly community, member of our friendly community, take a moment and write us a great review on Twitter, LinkedIn, Facebook, Google. I'm not sure what the white arrow is actually. So because I am not very good at social media. So thank you for listening to us today. I hope that you've enjoyed today's, I don't know if it's enjoyed actually when we're talking about Brexit. We still really don't know what is going on. And thank you very much for listening to me today. I hope to speak to you again soon, and it's goodbye from me.